That's thanks to Wanika Fisher telling me he uses a doormat.
Are we ready?
Not yet. It's not connected.
Okay.
Now it's connected.
Okay. Good afternoon. Welcome to the House Judiciary Committee hearings on January the 15th, 2021. It's 1:42 in the afternoon. A note for members right out of the gate. If you're assigned to the annex where you're going to be sitting when we do floor sessions, if you're assigned to the annex and you're on the campus today, you need to go to the annex to have your voting system security verified. You have to do this in person. If you're if you're going to be sitting in the House Annex and you cannot get to the House Annex today, you need to contact Alex Hughes and let her know. Members, please set yourselves on mute, which it looks like you all have.
Question.
Yes, Delegate Conaway.
Is there a time period for this?
You need to try and get there, I think, before 4 or so. So
I think we'll be over by 4?
We should be over by 4, I think, yes.
Thank you very much.
All right. Set yourselves to mute, only unmute when I recognize you to ask a question. After a witness testifies, you can ask questions by selecting the raise hand feature on your Zoom window. Witnesses, you'll unmute yourselves when I recognize you to present your testimony. For the sponsors of the bills that are on here, just letting you know, we're going to try it a little different today from yesterday. I'll give you the option to give the names of a couple people you would like to testify immediately after you, and I'll recognize them first. So you'll have sort of a panel. My intention, if we have more than 5 people, will be to call 5 witnesses at a time and then do questions after each group of 5. That I think is better than having people ask questions after every individual witnesses. Per the guidelines, House Bill 39 is going to be 2 and 1, 2 minutes for the sponsor and 1 minute for witnesses. The remaining bills today, 378, 154, 308, and 55 are 3 and 2, where the 3 minutes for the sponsor and 2 minutes for the witnesses. We don't have a clock yet, so I use my powerful phone to run the clock a little bit, and it gives a nice little quiet, apparently, ring, but we're working on the clock a little too. All right, is there anything else? I don't see anything else. And so with that, the first bill I have is Delegate Shetty's bill, House Bill 39. Delegate Shetty.
Thank you, Mr. Chair, Vice Chair Atterbury, members of the Judiciary Committee. Thank you for the opportunity to testify today in support of HB 39. This bill is identical to a bill that passed unanimously out of the committee and out of the House last session. This bill will help simplify and update the name change procedures for those who are currently required to go through our courts by removing the publication requirements for those who file a motion to do so. This bill deals with removing publication, but only the publication requirement. What it does not do is alter any other element of the process to change a name. It does not relitigate whether an individual can or should change their name, nor does it affect in any way any of the existing laws regarding crime victim notification. All of those requirements remain entirely intact with this bill. All this bill does is allow an individual who has already gone through the existing rules relating to name changes to petition the court to waive publication. There are several groups that would positively be impacted by the removal of this requirement, many of whom are represented on the panel today and whose testimony you have in your bill file. There could be devastating and dangerous results for victims of domestic violence who are seeking to change their name as part of the process of separating from an abuser. Similarly, individuals who are transgender and are seeking to be identified by their preferred name face unnecessary barriers and possible violence from the requirement to out themselves via newspaper publication. In either of these scenarios, not only is this requirement unnecessarily costly, but this information will also remain forever available to anyone who wishes to find this information on the internet. A growing number of states have removed this requirement to publish via name change. States including Alabama, Louisiana, Mississippi, Texas, Virginia, and Connecticut have all removed the publication requirement. This is a holdover rule that was created when creditors required notice to ensure that debtors did not abscond from their debts. Because credit now follows an individual's social security number, not your name, this requirement is no longer necessary. Changing an individual's name is a personal decision. It should not be subject to unnecessary added barriers, particularly ones that could result in harm to the individual. I urge the committee to again favorably report HB 39. Thank you. Mr. Chairman, I think you're on mute.
Yep. Gotta get it right. Get it right Sunday. We're going to hear from three witnesses each for 2 minutes. Lee Blinder, CP Hoffman, and Melanie Shapiro. 2 minutes each, please. We'll go with Lee Blinder.
Good afternoon, esteemed chair, vice chair, and committee. My name is Lee Blinder. I use they, them pronouns, and I am the executive director of Trans Maryland. I'm speaking to you on behalf of our organization as a proud non-binary transgender Marylander who assisted 220 plus trans people last year with the process of name and gender marker change. Every day I talk to trans Marylanders from ages 18 to 75 plus who are fearful of having their name change publicized. The trans community deserves privacy and dignity at this time of great joy as we seek to live and to be seen as our true selves. Each time I must tell an 18-year-old at one of the most empowering and exciting times of their life that their former name will be on the internet for the rest of their life is among the hardest conversations that I have in my work. That joy and excitement at being seen is dashed, and worry, fear, and embarrassment take over. I thank the committee for this time, and I ask you to please support HB 0039 and the dignity of transgender Marylanders. Thank you.
Thank you. CP Hoffman.
Thank you. Honorable Chair, Vice Chair, members of the committee. My name is CP Hoffman. I'm the legal director at Free State Justice, which is Maryland's LGBTQ advocacy organization. Over the last decade, Free State Justice has represented nearly 500 transgender Marylanders through the name change process and the courts. One of the most common concerns, as Lee Blender just noted, that our clients have going through the process is the publication requirement. In many cases, our clients are very concerned that it's going to put them at heightened risk going forward in their lives, especially now that so many papers publish these notices online and many leave them online forever. We've had people come to us, for instance, who have changed their name several years ago. And the first thing that comes up on Google under their new name is that publication notice that tells potential employers, potential landlords, individuals they interact with in the world, et cetera, that they are trans, and it identifies what their former name is. And it, many of our clients, or in fact, almost all of our clients, believe that it decreases their safety and it makes it more difficult for them to find stable employment and housing. Yes, so recognizing this, many courts have, in Maryland, have in certain instances granted waivers of the publication requirement. The problem is that there's been a lot of inconsistency between the courts. So Baltimore City, for instance, grants waivers for trans individuals pretty regularly, but Baltimore County does not. Similarly, in the DMV, Montgomery County routinely grants waivers, but Prince George's County does not. So this bill would create a level floor for people regardless of where they live in Maryland. We've also seen a number of issues over the past year because of the COVID pandemic. For a while, courts that had been granting publication waivers were not doing so because they weren't sure where to post notices in the courthouse if the courthouse was closed. By eliminating the publication requirement, or at least allowing waivers from it, we would be running around that issue in the event that courts end up being locked down completely again because of the pandemic or other situations.
Thank you very much
today, and I encourage a favorable report on HB 39.
Thank you very much. We'll go now to Melanie Shapiro for 2 minutes.
Sorry.
Please.
Yeah, thank you. Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. I am Melanie Shapiro, the Public Policy Director with the Maryland Network Against Domestic Violence. We are the State Domestic Violence Coalition working towards reducing intimate partner and family violence in Maryland, and we support House Bill 39. As Delegate Shetty has already indicated, the entire process to apply for a name change is not being altered at all by this bill. What is being removed simply is the requirement that it be published. A petition still needs to be filed. The basis for a name change is subject to judicial review. Specific notification is required under certain circumstances, especially if a minor child is involved. However, the removal of the publication requirement is especially significant for survivors of domestic violence. The new publication requirement in Maryland Rule 5901 requires that it be published in a newspaper of general circulation in the county of residence of the petitioner. So for a survivor of domestic violence that is seeking to establish themselves with some sort of anonymity and separate themselves from their abuser, they must then publish their name and the name that they seek to change to in their county of residence in general circulation. And as the prior panelists indicated, that information is very easily found on the internet now. And so for all of those reasons, we are asking for a favorable report on House Bill 39.
There are questions for this panel. We'll start with Delegate McComas. You need to go off mute, Delegate. There you go.
Thank you, Mr. Chair. Quick question. In our family right now, there's a big buzz about genealogy and getting finding out all kinds of information about the family. My question is, it's been a long time since I've done a name change, but in other words, if let's say the person's name is Andrea Jones, and then she changes it to Andrew Jones, and the family just knows there was an Andrea Jones, but they don't know about Andrew Jones. If they looked for the court filing of the name change where she lived, would they be able to kind of track the genealogy there? Or in other words, would they be able to locate her or him at that point? Just for family connections, and family argues over pictures and all kinds of stuff. And I just was kind of wondering if there's a way to track that. I'm not out because I voted for the bill the last time, and I understand the issue of publication. I'm just wondering if family members want to find out, want to locate the person or locate the genealogy and the history and the health issues and all that kind of stuff that families are interested in.
So this is like under the assumption that somebody has maybe done like a DNA analysis under like Family Tree or Ancestry.com, and then they're trying to locate others who might have also done the same to match with them?
Well, yes, or someone just wants to go to the records. Okay, let's say that the court records, the land records, the church records or whatever, and be able to kind of get more information about the folks that they're linked to, whether they be cousins or aunts, uncles, grandparents, whatever.
Yeah, so nothing in this bill would require that the records at the courthouse be sealed, if that's what you're asking. So those records would still be there. This is just removing the publication requirement, so it wouldn't be like accessible via Google search, or like if you went to a periodical of wide circulation in the jurisdiction, you wouldn't be able to find it there. But nothing in the bill changes any requirements by the court on maintenance of the public record.
So in other words, name changes are not sealed by automatically.
No, they're not.
Okay. Would this allow someone to seal if they wish to, as well as to not have in other words, if your bill passed, would they still be, let's say for some reason, they just really were very concerned about who they're dealing with elsewhere, whether it be a domestic violence or some other issue, that they could, if they showed just cause, to be able to continue to seal it?
So I would defer to some of the panelists here for their expert advice on it, but my answer is that I don't believe that this changes any existing discretion that the court has under existing court rules to grant a separate motion to seal the record should that individual feel that they need to make it. But I would defer to, we have several folks who do this work every day in Maryland. So I don't know if CP or Lee or Melanie would like to answer that or provide any further.
Yeah, so this will not affect the standard for sealing cases. There's a general standard that the courts use to determine when to seal cases. And there are many situations in which trans individuals do request that their name change cases be sealed. Sometimes they are granted, sometimes they are not. Not everyone requests that for various reasons. So this would not affect the existing standard. So I don't think that it's a huge concern for this particular bill.
Right. This bill only, Delegate McComas, this bill only speaks to the publication requirement. So it only, requires that it be waived should an individual who is seeking to change their name make a motion to do so. So this is only about the publication. This doesn't affect any of the other components of rule change or name change, rather.
Thank you.
All right, thank you all very much. Are there further questions for the advocates for the bill? Seeing none, we thank you all very much. We have one person in opposition, Vince McAvoy.
Hello, can you hear me?
Yes, we need to be able to see you as well.
Okay, thank you. Sorry, that's impromptu. Hello, committee. Thank you so much for hearing. In Maryland, citizens' actions involving state legal action are recorded. This includes entries of attorney, trusts, child custody, domestic violence. To pass this for a narrowly, it sounds like this is really just aimed toward one group. That one group's not mentioned in the actual name of the bill. It allows to an abuse of the system to exempt that one class because of their feelings or the lack of confidence about a step that they're about to take for their personal decisions or lifestyle choices. The issue of domestic violence was brought up. We have the GOCCP that has expanded their role to help such people who have certifying problems with people tracking them and so forth. So that's sort of new to this publication issue. I want to point that I personally know child custody cases where this name change has been abused. And this is the only time, if you actually look at Section G in 901, this is the only time that there might be any public notice. In other words, the court can operate pretty much a sponte on this issue. I strongly urge it to be favorable on this, and let's be genuine about actually what the name of the bill is and what we're actually trying to do. Because this will, if we look at the case in Texas where James Younger was involved, we absolutely have parents acting unilaterally to abuse the system, and that remember that this is just the safety net. This is the last step that's keeping someone from abusing the system. When we take these things out, we have no publication, we have no notice in the public, and we have no safeguards whatsoever. Thank you for your time.
Thank you. Are there questions for Mr. McAvoy? And the next time that Mr. McAvoy testifies, we're going to ask him to turn on his camera. Are there further questions for Mr. McAvoy?
Okay, will do.
Seeing none, thank you very much. That concludes on House Bill 39. We're going to go committee to House Bill 55 and hope that Delegate Crosby is still with us. Here he is. Delegate Crosby, I believe that you're the only person testifying on this bill. Is that correct?
Correct, Mr. Chair.
Okay, just you? All right,
Just me.
You've got 3 minutes. Go right ahead. This is House Bill 55.
Good afternoon, Mr. Chairman, Vice Chair, and distinguished members of the committee, Delegate Brian Crosby, and it's an honor to present House Bill 55. As many of you will remember from my testimony on this bill last year, this will remove charitable immunity protection in cases where agents of a nonprofit in the course of their duties have committed sexual assault or rape. Charitable immunity simply is a legal doctrine which holds that charitable organizations are not liable under tort law. In Maryland, charitable immunity applies if an organization carries liability insurance and then caps the recovery of the limit of the insurance policy. So in essence, it creates an incentive for organizations to game the system by carrying low insurance protection. The concept of charitable immunity was originally based on the idea that funds raised from a charitable donation should not be used to pay civil damages because donors intend their donations to further those charitable goals, not cover legal bills. And that's a good policy. But in Maryland, this practice has become a safe harbor for organizations that do not take sexual assault seriously. We're only one of 9 states where this policy still applies, along with Alabama, Arkansas, Georgia, and Utah. And as a result of this policy, many survivors of sexual assault are unable to receive the appropriate compensation for the trauma they endured. Last year, you heard favorable testimony from the Maryland Coalition Against Sexual Assault, asking for an amendment that would make minor technical adjustments. We've already included those. And this year, their executive director, she couldn't be present. However, she did submit favorable testimony digitally. Based on these reasons, I ask for a favorable report on House Bill 55.
Right, there is, Mr. Yost is going to be testifying today from what I understand, and he is on the Zoom. Mr. Yost.
Can you hear me?
I can. Can you turn on your camera, please?
Okay.
Maybe.
Perfect.
There we go. Great. All right, Mr. Yost, go right ahead. 2 minutes.
Chairman Clippinger, delegates, the original, I'm urging you to vote favorably for House Bill 55. The existing law, Courts and Judicial Proceedings, Article 5-406, has broad immunity for anyone who's working within a charitable organization, as well as many other types of organization. The definition of what works to be immune is very broad. It's the first 3 pages of the article in the bill. And what this bill seeks to do is to carve out a very small exception from that civil immunity, and that is for sexting, for sexual abuse, and for revenge porn. Those 3 exceptions. So if you have an employee that works in your homeowners association that qualifies, and this person is sexting or sending revenge porn or what have you to other members in the course of working for the homeowners association, he's completely immune right now. And the organization's immune if he does it. But, and this bill is a prospective bill, it's only to take effect going forward, but this bill would now make him liable. Number one, he would not have this automatic immunity. And number 2, the organization would still not be liable so long as they bought some minimal insurance. And that insurance is described as having $200,000 per claim, $500,000 per incident if it affected a lot of people, and $750,000 per year. Based on the size of some of these organizations, that's not a whole lot of coverage because there could be a lot more harm done. But even if there's more harm done and the insurance is exhausted, the organization still has immunity. The individual would have immunity also if there's insurance, except that if the individual acted with malice or if they acted with gross negligence, they could still be personally responsible for sexting, for sexual abuse, and for revenge porn. When this bill was originally, when the Courts and Judicial Proceedings was originally enacted, I don't think anybody would have imagined granting immunity for this type of conduct. This is a very small carve out of a very broad grant of immunity, and I would urge you to report favorably on House Bill 55. Thank you.
Are there questions for the sponsor or the witness? Delegate Arakan.
Thank you, Mr. Chairman. Thanks for bringing this bill forward. Correct me, we had this bill last year. Do you remember the bill number for last year? It's not showing up on my system.
I do not, but we can get that to you.
Okay, and I would love to know sort of, was this unanimous? Did this leave our committee unanimously? I think it may have. Oh, Mr. Chairman, are you talking? No.
I don't believe that this this left the committee last year.
It did not. Okay. Well, I like.
It did not, and it is House Bill 201, delegate.
Okay. Okay. Thank you very much. Okay. Yeah, this actually happened to my mother not that long ago. She was harassed sexually by an HOA employee, and there was almost nothing that could be done. So thanks for this bill. It's a good one.
Are there further questions for this panel? Seeing none, thank you all very much. Appreciate it. That concludes the testimony on House Bill 55, and now we will go back to the regular order and go to House Bill 378. This is Delegate Deborah Davis's bill.
Thank you, Mr. Chair, Madam Vice Chair, members of the Judiciary Committee. For the record, my name is Delegate Deborah Davis. I'm here to present HB 378, House Bill 378. It's titled Local Government Torts Claims Act, Definition of Local Government. That's important because this bill, when passed, will simply add the Maryland Association of Counties, otherwise known as MACO. It would simply add their pooled OPEB trusts to the definition of local government. And let me back up a little bit. OPEB is simply a retirement fund. It's a trust that's set up by local government insurance trusts. And OPEB means other post-employment benefits. So they've established a trust. They would like to add it to the definition of local government so that they can get the benefits of the pooled trust. And let me back up just a little bit. So for those of you who don't know, the Local Government of Insurance Trust is an organization that acts a lot like an insurance company. And in 1987, the local governments in the state of Maryland organized, pooled their resources to offer insurance to each other. So since then, counties, cities, and towns are able to buy reasonably priced insurance coverage from local government insurance trusts. So, and since 1987, other organizations, other entities have been added to that list of to the list of government entities so that they could be covered. So we're simply asking that MACO's OPEB trust be added. And when it's added, it'll be the 30th additional organization to be added. In 2016, we added the Tri-County Councils. The Tri-County Council of Southern Maryland was added at that time. Michael Sanderson, who is the executive director of MACO and is also a trustee of OPEB and Legit, is signed up and available to answer any technical questions. We respectfully request a favorable report for HB 378. Thank you.
All right, Mr. Sanderson, you have 2 minutes.
Thank you, Mr. Chair and Madam Vice Chair, members of the committee. I'm Michael Sanderson with the Maryland Association of Counties. First, let me thank Delegate Davis for her introduction of the bill and also for her leadership in county service and in her years past. You've already heard the basics of what the bill is about. There are already a couple dozen cases where you've taken a not quite government entity that conducts what's basically a governmental function and classified it under the Local Government Tort Claims Act. So as the delegate mentioned, this would be item 30 on an already existing list for exactly that purpose. The members of this board of trustees basically collaborate to manage and invest funds on behalf of one another's local governments. They're doing the right thing, making investments of today's dollars because tomorrow we'll need them to pay for healthcare for our retirees. It's a good best practice and a good thing to be supporting. What this bill does is it helps to ensure coverage for those individuals in local governments who volunteer their time to be part of this this pooled entity. And second, and really the main purpose for the bill is we are right now, this special trust is out in the private market trying to get insurance from travelers and the like who really don't understand the nature of an advisory board like this and what they do and what it means to insure them. We just got our latest bill for a year of premiums and it's over $21,000 for what will almost assuredly count as nothing. If this bill passes, we can go to local government insurance trust who understands this board. They already insure library boards and other roads boards and things like that. They get what this is about. So that's what this bill is ultimately about. I'll just say as a trustee of MACO and of this OPEB trust, we're very proud of what we're doing. And this bill would provide a little cost savings and a little help for folks who are doing the right thing. Thanks very much.
All right, thank you. Are there questions for the panel? There are two so far. Delegate Griffith to begin, and then we'll go to Delegate Williams.
Thank you, Mr. Chairman. Thank you, Delegate Davis, for bringing this forward, and Mr. Sanderson. My question ties around, so to recognize you as local government certainly it would help you with the trust fund, but what are the other impacts on MACO for moving this forward in terms of liabilities, being tied to government more, being able to be independent, these type of things? I'm very, very concerned about the other impacts beyond this. Is there a way to make sure this is very narrow in scope, or to make that determination it's just broad and pulls you into the entire umbrella of that definition?
Would you like me to answer?
I can do my best, Delegate, if it would be helpful.
Either way is fine.
If you look at the statute, Mike, or Delegate Griffith, it is already narrow because it's only under a special section of the Tort Claims Act. It's only under a special section, and there are people who have already been added, like the Howard County Economic Development Authority, the Lexington Market Incorporated of Baltimore City, the Washington County Free Library. So it actually fits. These are agencies that are conducting government-related work.
And I would add, if I may, Delegate, that the Local Government Tort Claims Act sort of provides a two-way relationship between these entities and their employees. So in the event that a member of this trust were to be sued, he or she wouldn't be left out to dry. Being under the Tort Claims Act means that the trust has their back and would indemnify their losses. If you're the person suing the trust, which seems odd that it would happen, but in the event that that were to somehow happen, that means that you have an entity that could satisfy a judgment rather than going after the individual. We wouldn't want to have like the finance officer of the town of Bel Air personally on the hook for a lawsuit. It's better that the entity does it if there's an error or omission in our coverage. But this is only for purposes of the Maryland Local Government Tort Claims Act and our ability to be classified as a local government just for that one purpose.
So it's, okay, and that's what I'm trying to clarify, just for that one purpose, very narrow scope. Thank you.
Delegate Williams.
Yes. I don't know who can answer this, either one. I guess my only question I have is whether or not I understand that there are other like CDCs and things like that that are defined as local governments. Are there any other kind of trust or pension funds? Because that's what this sounds like it is, that I understand that MACO is, I guess, a trustee of. But are there any other types of pensions or trust funds that are also currently defined as a local government under the Act?
I'll try and take that, if I may, Delegate Davis. There's a list of about 25 different units and classes of units. There's not another investment trust fund that's quite like this, but there are some groups that are really parallel in that they're multiple units of local government working together to do a function that like a bigger county would do under its own umbrella. Baltimore County government might well have an investment committee to guide their OPEB investments for down the road. But the whole idea of this pooled trust was that these smaller units of government don't go out and hire a lawyer and do all this overhead. Let's pool the overhead together and save money, including the insurance, candidly. So there's not a perfect parallel to this, but honestly, the smaller local governments, instead of pooling for pensions per se, they mostly participate in the state pension system, which would itself be covered under the State Tort Claims Act. So that's also a pretty good parallel. But from time to time, your committee considers bills like this to add one more unit to this list. That's what we're asking you to do this year.
Delegate McComas. You muted yourself.
Okay, sorry about that. Thank you, Mr. Chair. Just briefly, I was on the claims committee for Legit a long time ago.
Very good.
Dealt with litigation, negligence, all kinds of stuff, police misconduct. And I guess I'm trying to get a handle on this. Is this just for the trust for OPEB for the counties, or does it also include the municipalities? And is MML also supporting this?
I can speak to that. I think, first of all, what this bill would allow would be for legit insurance to cover the trustees in their capacity, just in their limited capacity of participating in this little entity. So if you're the finance officer in the town of Bel Air has coverage for you already, but when you drive to a meeting or Zoom to a meeting of this body, your decisions and actions are in a different capacity. We want to cover you when you wear that hat. As it turns out, right now we have around a dozen participants, including both county and a couple municipal governments. Actually, I mentioned the town of Bel Air, city of Annapolis, both participate. We have a couple libraries and a couple community colleges. So it's a mix of local entities. It's open to the Maryland Municipal League. I don't think they've put in a statement, but I'm sure they would be equally supportive of the bill.
Thank you.
Are there further questions? Seeing none. Thank you all very much. That concludes the testimony for House Bill 378. Now we're going to go to House Bill 154 and Buddy's Law with Delegate Bartlett.
Thank you, Mr. Chairman, Chairman Clippinger, and Vice Chair Atterbury. For the record, I'm Sandy Bartlett from Anne Arundel County. Committee members, I come before you today to urge you to vote in favor of House Bill 154 to raise the amount of compensatory damages for the tortious injury of a domestic pet from $10,000 to $25,000. There are not many cases in which compensatory damages due to injury to domestic pets run as high as $25,000, but as you can see in the law, only certain types of damages can be, because as you can see in the law, only certain types of damages can be claimed. In those few cases where the injury is as high as $20,000, $25,000, or $29,000, the current law leaves no remedy. The section of the law that we're talking about is CJ section 11-110. It compensates pet owners only for economic damages due to tortious injury to a pet. And it provides for the fair market value of the pet before death and the reasonable and necessary care of veterinary care. There's not a lot of wiggle room here. The pet owner has to prove damages through evidence. House Bill 154 in no way guarantees that pet owners will receive $25,000. His or her claim for compensatory damages must be substantiated in injured pet cases the same as in any other civil case. Not every case will be as high as $25,000, but you will see from the written testimony that's been submitted of Larry Sanders that his vet bill exceeded $25,000 when his family pet was shot and later got an infection and died. House Bill 154 raises the amount available to pet owners who can, one, prove that the injuries to the pet were caused by another person or another animal within someone's control, and two, that the injuries sustained to their pet were as a result of the other person resulted in vet bills or a complete loss. For these reasons, I urge the committee for a favorable vote. And I also wanted to bring to your attention from the Maryland Association for Justice, who is sending out testimony to each committee member, a section of their testimony. When any kind of property in Maryland other than a pet is tortiously damaged or destroyed, the wronged property owner can sue to recover the actual costs associated with repair or replacement of the property, plus damages for loss of use and enjoyment, plus prejudgment interest without any statutory cap or limit. Only pet owners are limited to what section 11-110 allows. I also want to point out that the cap to section 11-110 was amended in 1999 to $5,000. In 2005 to $7,500, and finally in 2017 to $10,000. In each case, the cap was considered unjustly low, and the General Assembly increased the cap in order to avoid injustice. Every one-size-fits-all cap on damages eventually will be unjust because arbitrary caps never allow for exceptions. And in the case of Larry Saunders, we have an exception. His testimony is presented. He was not able to be here today because he's out of the country. Committee
Delegate
members,
Bartlett? Yeah.
thank you. Yep, I thank you for your time.
All right, thank you very much. Testifying in favor. We'll hear the testimony of David Wildberger, then we'll take questions. I already see one from Delegate Carden. David Wildberger.
Good afternoon, Mr. Chairman, Ms. Vice Chair, and members of the committee. Again, I'm David Wildberger. I'm here on behalf of the Maryland Association for Justice to urge your favorable report on House Bill 154. As you've heard, this bill attempts to amend Courts of Judicial Proceedings 11-110, which, as far as I know, is the only statute on our books that limits recovery of compensatory damages for injury to property. Now, the concept of our pets being property is interesting because, in fact, they are property, but they are a unique type of property. They are a type of property that can love and be loved. They have a very special place to us individually and as a society. It's kind of incongruous in that regard that the only damage cap on property is for pets. But if we're going to have a cap, it needs to be a reasonable cap. Anyone who has had to take a pet to an emergency hospital, had to pay for surgery, knows how expensive these things are. And as a delegate said, this is only going to really apply to a small amount of cases, but it's a justice. You have to prove your damages. And frankly, there are going to be times when pets are killed by negligence. There's not going to be any damages. If somebody wanted to kill my rescue cat, there would be no damage I could collect because I would have no vet bills because the cat died and because the cat isn't worth anything because it's not a purebred. So this is a narrowly constrained bill, and it's going to only apply when there are very, very large damages that have been caused by negligence to someone's beloved pet. And I think it's a reasonable bill, and I urge you to support it as the first step toward addressing the issue. And thank you so much. I very much appreciate the opportunity. I wish I could be there in person with you. This is the first time I've done this. This is an interesting experience, kind of a nerve-wracking experience. I was hoping it wasn't going to mess up the technology. Hopefully I didn't. And again, thank you so much for your time.
Thank you. There are two people who would like to ask questions. The first will go to Delegate Carden, then to Delegate Juanita Fisher. Delegate Carden to begin, please.
Thank you, Mr. Chairman. Thank you, Delegate Bartlett, for this bill. I love this bill. Isn't it true, though, that you can't get punitive damages for a pet, for a case against a pet? Is that true?
Are you saying, isn't it true that you can't not?
You cannot.
Well, you cannot, right? You cannot. You
Right.
can get punitive damages for other torts that you bring in based on that injury that was done to a pet, like in the Brooks v. Jenkins case.
But this is really where you would get most of your compensation if somebody really hurt. If for example, I took my pet to PetSmart, and they dropped the pet on the floor. She broke all of her legs and had to deal with surgeries and pain for the rest of her life. The maximum at this point I could get would be $10,000, even though the surgeries themselves might be more than that. Isn't that?
That's correct. And if Mr. Wildberger wanted to elaborate, please feel free to do so, if that's okay, Mr. Chair.
Sure. Delegate Carden, in terms of punitive damages, Maryland probably has the most restrictive law on punitive damages in the country. It is virtually impossible to give punitive damages here. And I don't think they would be reasonably available for an injury to a pet. In terms of, you're exactly right. This is going to apply when there's been a massive damage to a pet and there has been massive vet bills. or when a pet has been killed and it's a purebred show dog, something like that. Those are the only circumstances in which this change in the law is going to apply.
Thank you.
Okay, we'll now go to Delegate Juanita Fisher.
Thank you, Mr. Chair, and thank you for the Wanika. I appreciate that. I have a question about malpractice with pets. Is there, if you're a vet, is there malpractice or laws and ways to sue when a vet does something to any kind of pet, and what is that framework? Very briefly.
Delegate, if you'd like me to answer that, I'll go ahead. Yes, you would sue a vet under the same sets of common law tort principles as you would anyone else. You would have to prove, however, that the vet was negligent in the treatment. And to do that, you may well probably do have to have another vet come in and testify about why the vet was negligent. Again, that's a good reason that this cap should be raised, because you're, in a large enough case, you may have expert witness expenses, in addition to, lawyer fees for these cases. But yes, it is. You would use the same principles that we would sue pretty much anyone else, although maybe with the need of a expert testimony for a jury or a judge.
Okay, are there any further questions for advocates for the bill? Seeing none, thank you very much.
Thank you.
Opposition to the bill, I see Andrew Kirkner and Bob Ensign. So for that, we will go to Mr. Kirkner first for 2 minutes, and then Mr. Ensign for 2 minutes. Mr. Kirkner.
Hi, good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. I appreciate the opportunity to speak before you today. My name is Andrew Kirkner, and I'm here on behalf of the National Association of Mutual Insurance Companies and our more than 1,400 member companies to unfortunately ask for an unfavorable report on House Bill 154. I say unfortunately because like many of you on this call, I too am a dog lover, and I understand both the emotional importance and value that they bring to our lives. I said dogs, which was a bit of a Freudian slip, but all pets bring to our lives. That said, and I understand the good intentions of the bill. That said, in the testimony, I've not read the written testimony submitted to the committee, but I think one of the things that's been missing so far is any evidence that the $10,000 threshold is too low. There is, obviously, the committee has been presented with an anecdote in one case where those bills ran in excess of $10,000. But I would just again point out to the committee that this damages cap was just raised in 2017 to a $10,000 threshold. There's no question that vet bills are expensive, but the $10,000 threshold appears appropriate, certainly in the absence of any type of data that would support an increase to that number. I think the other thing, Mr. Chairman, I would briefly point out before concluding is that, this is an area of the Maryland Code where compensatory damages are specifically laid out, what they're intended to cover. And here they're intended to cover, in the case of a death, the fair market value of the pet, or in the case of and vet bills, or in the case of an injury, vet bills. What you don't see in that definition is attorney's fees. And I would encourage the committee to keep in mind that when you raise the threshold to $25,000, there may be some additional motivations that enter the equation. Finally, Mr. Chairman, I would just say to the committee, there are additional products on the market, in the private market, for pet insurance. Pet insurance is a growing market for insurers. This bill does nothing to impact an individual pet owner's ability to go out and secure insurance for their pet well in excess of $25,000. And I'd be happy to supplement to the committee with more information about what those products look like, but I did just want to point out that they are available. Thank you very much.
Thank you very much, Mr. Kirkner. We'll go now to Bob Ensign. Mr. Ensign needs to be off mute. He's figuring it out.
Okay, is that better?
That's better.
All right, thank you very much, Mr. Chairman, members of the committee. Robert Ensign on behalf of the American Property Casualty Insurance Association. our members write about 2/3 of the property and casualty insurance in the state of Maryland. I had a very nice conversation with the sponsor the other day and discussed with her what our concerns were. And I appreciated that opportunity very much. We are signed up opposed, and kind of in line with what Mr. Kirkner said. I mean, I did the research, and I'm trying to find my note here. This law was originally enacted, I think, in 1989, $2,500. And then in around 2000, 2005, it went to $5,000. Then it went to from $5,000, $7,500. And now in 2017, it got up to $10,000. Certainly, you know, and now to come back 4 years later with a 250% increase seems like an awfully big rise to us. I mean, inflation is going at what, a rate of about 2 or 3% per year. I'm just not really aware, you know, and I don't, you know, from our industry point of view, when we talked about it, I think it's very, very rare to have a claim that's frankly today in excess of $10,000. Typically, if a dog has, and I've had 3 golden retrievers and 4 cats in my life. When your pet and the cat was the last one that got sick, and I don't know, we probably spent $2,000 or $3,000 having it treated, but then we had no choice but to put it to sleep. And I think that's what typically happens when you get medical bills that get up anything even close to $10,000. It's probably maybe a lost cause. Or certainly have sympathy for anybody who loses a pet. I've lost them, but it just seems to us that this is an awfully steep increase and not much evidence that the current cap is a problem. So on that basis, at least for today, and you know, based on the amounts and what we just did 4 years ago, I really almost, if the bill went into effect on October the 1st of 2017, really only 3 years ago, I think this would be a really big increase. And based on that, with all due respect to the sponsor, we'd ask for an unfavorable report.
Thank you very much. Are there questions for the opponents to the bill? Delegate Fisher, Delegate Juanita Fisher, you have your hand raised in the chat, but I think that was just because of before. So, okay. Are there any questions for opponents to the bill? Seeing none. Thank you all very much.
Thank you.
Testimony for House Bill 154. We will now go to, I believe, our last bill. I think. Yep. House Bill 308. House Bill 308, Delegates Rosenberg. And let's just make sure. Okay. Delegate Rosenberg has 1, 2, 3, 4 other people to testify. What we'll do, we'll hear from all 5 of them. Delegate Rosenberg, it sounds like this bill is back in its initial posture, if I'm not mistaken. So we're going to give you 3 minutes to start, and then 2 minutes for each of the witnesses, which will be Rebecca Snyder, Jim McLaughlin. Rebecca Snyder, Jim McLaughlin, and Paul Levy. There are only 3 other people, so that's fine. Okay, so we'll start with Delegate Rosenberg. Thank you.
Thank you, Mr. Chair and Madam Chair and members of the committee. As this committee well knows, having worked on this issue last year and having passed legislation to the floor, SLAPP suits, strategic lawsuits against public participation, are designed to prevent the average citizen, the little guy, from participating in public activity, from exercising his or her First Amendment right. We have an example, a very significant example in Baltimore City within several months, a $25 million lawsuit brought by a property owner against the homeowners in a condo who spoke in opposition to a proposal of his for an adjoining property. One of the issues in that suit was whether bad faith had been demonstrated by the property owner. That is one of the changes that last year's bill made, that is removing from the law the requirement to establish bad faith on the part of the original plaintiff. Last year's bill also broadened the definition of a SLAPP suit, what constitutes a SLAPP suit, to include a broader definition of First Amendment activity, that the existing law, the original law, pertains to First Amendment activity in a public forum, or specifically, most notably in a public forum. What this bill would do, in addition to the bill that the committee passed favorably on last year, would be to provide that the party that has been slapped, the defendant, can ask the court to rule expeditiously on the SLAPP suit, on the claim of a SLAPP suit. That's integral to the process, because one of the purposes of the SLAPP is to force the defendant to engage in costly and demoralizing discovery. And so an expeditious hearing would address that. The other provision that is new to that is in this bill, that is not in last year's bill on third reader, is that product liability suits and trade practices lawsuits could not be considered a SLAPP suit when brought by an individual or a group against a business, corporation, or entity. So Maryland was one of the first states to enact a SLAPP law. Other states have now gone beyond us in terms of the strength of their laws and adapted them to how those who SLAPP have responded to such laws. And so we would urge a favorable report on House Bill 308. Thank you very much.
Rebecca Snyder, please, for 2 minutes.
Good afternoon, Chair Clippinger, Vice Chair Atterbury, and members of the committee. I am delighted to sit in front of you today to talk to you about House Bill 308, and thanks to Delegates Rosenberg and Cardin for bringing the bill again this year. I'll let Paul and Jim talk about more of the legal and technical aspects of the bill. I'd like to tell you why it's needed. And of course, we represent news media in Maryland, Delaware, and DC, and journalists need stronger anti-SLAPP protections, but citizens do as well. If you look at the dispute on Clipper Mill, which happened in June of 2020, and in my testimony, some of the specific examples that you're seeing, you'll see that everyday citizens need these protections as well, because they are being wrung dry by litigants with deep pockets who want to stifle free speech. And so SLAPPs at their heart stifle that public debate. They intimidate and they diminish civic engagement, and they threaten news reporting, which is why we're coming into the mix here. Those principles are fundamental to our democracy. This bill is especially important to members of the press because our industry really does we're struggling. The economic effects of any SLAPP suit can devastate a publication almost instantaneously. And if you think of how that works with news organizations, that's exacerbated by in an individual setting as well. So for reporters and news organizations, the time, effort, and expense that it takes to respond to frivolous suits just diminishes our capacity for news reporting. So it's money that's not spent on staff or other investigative reportings. And for many news organizations, SLAPP suits have the ability to chill their reporting and their willingness to report on certain stories. So we all know that any journalistic organization will sometimes make people uncomfortable if they're doing their job correctly. But we need to further that debate, and we support this legislation and urge a favorable report as you did last year. Thank you.
Thank you very much. We'll go now to Jim McLaughlin.
Thank you, Mr. Chair. Thank you, committee. And I apologize in advance if you hear dogs barking or see little kids running behind me. I've closed the doors, so hopefully not, but we're all adjusting to this virtual environment. As my written testimony indicates, I've testified more than half a dozen times in support of proposals to strengthen Maryland's anti-SLAPP statute over the past decade or so. And those bills have differed in some ways, but this is the strongest and best bill. I said this last year too in March, because this is substantially the same bill as Delegate Rosenberg noted. It addresses the two glaring weaknesses in the existing Maryland anti-SLAPP law, which are highlighted in my testimony, but just to quickly go over them here. The two big problems with Maryland's anti-SLAPP law are, first of all, the subjective bad faith requirement that Delegate Rosenberg alluded to. It's unique among the 30 or so state anti-SLAPP laws in the country in saying that a lawsuit is not considered a SLAPP unless it was actually brought in bad faith, to quote the existing statute. The reason that's a problem is that state of mind, the subjective state of mind of the plaintiff in a libel suit is not going to be known by a libel defendant at the outset of litigation, which is when anti-SLAPP motions need to be filed. Almost by definition, that standard is going to require some discovery. And the cost of discovery is in fact the harm that a libel bully is attempting to inflict on the speaker by filing a SLAPP suit in the first place. So it defeats the purpose of a SLAPP lawsuit if in order to, of a SLAPP statute, sorry, if in order to avail oneself of the protections of the statute, costly discovery is needed into the subjective state of mind of the defendant. House Bill 308 would remedy that by simply replacing it with an objective standard that's much more in keeping with that used in most other states that have anti-SLAPP laws. The second major problem in the existing statute is that it contains no fee shifting provision. The reason that's a problem is, as I said, the purpose of SLAPP lawsuits is to inflict legal fees. It's to inflict financial damage. It's not usually to win the lawsuit. Often these are clearly frivolous cases that aren't going to go anywhere. But a deeper pocketed libel bully is attempting to force a news organization or a citizen or whoever the case may be to
Mr.
incur
McLaughlin, if you could wrap up, please.
Okay, so this bill would impose a mandatory fee shifting requirement, which would address that problem as well. So the Post and the Press Association strongly urge a favorable report, and I'd be happy to address any questions that the committee may have. Thank you.
Thank you very much. We'll go now to Paul Levy, please. 2 minutes.
You bet. It's truly a delight to have an opportunity to testify on behalf of public citizen in support of this proposed bill, which provides strong support for speech on matters of public concern. We've seen anti-SLAPP statutes work effectively in other states to prevent the use of litigation to suppress speech that's not, when the litigation is not really based on serious concern that the speech is actionable, but in recognition that the very cost of defending by those who have no financial stake in the speech in the first place can take valuable contributions out of the marketplace of ideas, and it can chill the exercise of the right to speak freely about companies and individuals who establish a track record of suing their critics. I've litigated motions under several anti-SLAPP laws in various states. I've seen the good ones work effectively, and I've seen the limitations of the weak ones. A good anti-SLAPP statute discourages plaintiffs from suing over such speech unless they think they have good reason to prevail on the merits, that they can prevail on the merits eventually. It requires courts to take an early look at the merits of the cases, and it creates a financial incentive for lawyers in private practice to defend cases that have been brought over protected speech. And in that way, it enables those who have spoken fairly to stand up for their rights. Now, SLAPP remedies are strong medicine, and they should be drafted carefully to avoid impinging on the kinds of cases where consumers or indeed public authorities are pursuing economic justice against a big company. Such cases sometimes rest on speech. For example, product liability lawsuits might be based on a company's public misstatements about the quality of its products, and consumers shouldn't have to worry about facing SLAPP-style remedies for such lawsuits. HB 308 does a good job of excluding such cases from anti-SLAPP remedies. Now, my written statement suggests some modest possible improvements in the law, but with those slight qualifications, we urge the committee to recommend passage of this legislation.
All right, thank you very much. There is a question now from Delegate Arakan. Delegate Arakan, please.
Thank you, Mr. Chairman. I'm just wondering, Delegate Rosenberg, if you have the previous bill number. It's, for some reason, the system does not have any previous bill numbers, it seems like.
379.
Okay, thank you.
Further questions for the panel? Delegate Conaway, then Delegate Cox.
Thank you, Mr. Chairman. I can't get the raise my hand. So, Mr. Levy, in reference to what you were saying, what do you mean a person might bring a slap against someone that they don't have anything to do with the situation or with the business? I guess you mentioned that possibly someone could bring a slap suit against a business or entity that they don't have anything to do with them.
I'm not, so sometimes you have, say a false advert.
Yes, okay.
So you might have a false advertising case, right? Which
Yes.
could be brought by a consumer against business, or sometimes they're brought by businesses against other businesses. Those cases aren't really slap suits in the ordinary sense of the word. And one of the exceptions to HB 308 takes those out of the coverage of the anti-slap law, and we think that's a good idea.
All right. Thank you very much.
Delegate Cox.
Thank you, Mr. Chairman. Delegate Rosenberg, good to see you, sir. Last year, you were very gracious working with the committee on some language. Is this the same exact language that was passed from our committee last year?
No, it is not. This bill includes everything, all the changes that last year's bill made to existing law in terms of providing additional protections. But it would also, as Mr. McLaughlin said, it would strike the requirement of bad faith, having to prove that subjective standard. And it would also clarify that a lawsuit brought for product liability or for trade practices, the counter response could not be an assertion that it was a slap suit.
I'm sorry, that second part, I didn't quite follow. I apologize.
That's okay, sure.
I saw the subjective, that's I see that, that's clear. And what was the other change?
Okay, the bill would also exclude from the definition of a slap suit a trade practice or product liability claim that is brought, so that the business entity could not counterclaim by asserting that it was a slap suit.
Okay, thank you.
Because that is also another form, I would assert, of protected speech, bringing that kind of lawsuit.
Okay, thank you very much. Appreciate
Thank
that.
you.
Looking to see if there are any other questions. All right, seeing none. Thank you all very much. That concludes the testimony for House Bill 308. The testimony for our committee today before 3 o'clock. How about that? All right, we're done, and we will be back, I believe, on Tuesday with further bill hearings. Thank you very